All right, good afternoon, everyone. Welcome to ISP's virtual bootcamp webinar. Today's topic is Email, the 7 Deadly Sins, presented by Melissa Roberts. My name is Ariana. I'm the Education Specialist with ISPE. So as always, if you have any questions regarding today's webinar or our virtual bootcamp or any other of our education programs, please feel free to reach out to me. I just have a few quick announcements. The handouts for this presentation are available in the handouts section of your toolbar, and of course they're also on the website. You can find the link to the quiz on the same webpage. Please be sure and complete the quiz by this Friday so I can email you your PDA certificates as soon as possible. If you have a question for Melissa at any time during the presentation, please type it in the questions box, which can be found on your toolbar, and I can read them aloud as we go. I think that's all. So with that, I'll hand it over to Melissa.
Oh, fantastic. Thanks, Ariana. Thank you very much. And thanks to the ISPE for inviting me back again. It's always a delight and frankly a bit of a surprise to get asked back. So thank you. I'm happy to provide continuing education on risk management and insurance topics. So today's program is Email, the 7 Deadly Sins and Best Practices for Staying Out of Email Hell. Before I get this too far underway, though, let me give you a little background on this. USI, we write most of our own continuing education programs, but in this case, I viewed this presentation from XL Catlin earlier this year, and I just thought it was fantastic. XL is a professional liability insurer, and they built this entire program around emails they came across in claims or requests for risk management assistance from their policyholders. There's a lot of criticism of poor email practices, and sadly, it may hit a little close to home because a lot of it could be a reflection of our own email practices. And I had a bipolar reaction when to most of these illustrations, these real life claim illustrations that we're going to look at. One was either, wow, who really would think that that was acceptable? But, on the other hand, there were plenty where I thought, okay, under a lot of circumstances, I could see myself sending that email. So again, if you feel personally attacked during this program, I'm sorry for that, but maybe this will be, a great reminder to you and information to take to your colleagues about writing appropriate communications. And these emails are part of our daily lives, and they're a primary path of communication. And frankly, I'm grateful for email. I remember back to a time before there were emails when we typed out letters. So, you would get paper in, and then you would add carbon paper behind that, and you would roll it into the typewriter, and you'd begin to type. And if you made an error, you had to stop and white out each of the pages and try to roll it back in and line it up perfectly and continue typing. It was this long, laborious process. And it's not now, right? We can send emails almost as a stream of consciousness. It just goes quickly. And that's, good and bad. And when that original email first started coming out, for the first 6 months that we had email, we were learning what the, protocols would be for its use, what best risk management practices would be for this very, very new form and, again, immediate form of communication. And for the first 6 months, we really only used it for two things: jokes and receiving chain mail, neither of which would, pass muster by, today's acceptability standards. But these email, they can be constructive productivity tools, or when we don't do it right, they become a weapon that we really use against ourselves. So, we're in a litigious world. The litigious nature of this world makes it critical that we treat this very common form of communication with the attention that it needs, and think carefully about what we write and why we write it. So you're going to hear me say this phrase ad nauseum throughout this program: be thoughtful and be intentional. Don't treat words casually, because the courts won't. Courts look to two places to see what you mean when you say a particular word. First and foremost, or phrase, I should say. And, first and foremost, the court's going to look to the four corners of your contract. Is it clear within the context of the contract, what you meant by that phrase or what you meant by that word? If not, they go to where we all go, right? They go to the law dictionary. In their case, they'd go to Black's Law Dictionary. And so, be thoughtful and be intentional with these words. And by thoughtful, I sort of mean, yes, be kind. Certainly, I want everyone to be kind, but more importantly, be full of thought, be thoughtful. So this program is going to present real examples of self-implicating and subsequently weaponized emails, and we hope to offer up guidelines for writing more appropriate, perhaps shorter, and hopefully clearer messages. It does include a bunch of real claim examples that were sent to, XL Catlin by their, professional consulting clients, their design professionals. And with that, we'll get this underway. The takeaway is we want to help you write and email, these business purpose communications following the rules concerning the 7 deadly sins and the 10 heavenly steps for staying out of email hell. And one last thought before we start is, in terms of claims, the XL Catlin program identifies that by claim count, so not volume, not dollar amount of the claim, but by the number of claims, communication is identified as a risk driver in about 30% of the claims. So this is significant and hopefully will be helpful. Claims are never fun. They take a lot more than just a financial toll on a firm. It's not a pleasant process, and it's not fun waking up every morning thinking, oh yeah, that person doesn't think I do a good job. So whenever we can avoid it, and one of the ways to avoid it is through good email practices. Our learning objectives, we're going to help you recognize and comprehend email that might create a misunderstanding or might make a situation worse. I don't know that email always create the claim, but certainly email can make a bad situation even worse. And we're going to talk about that in more detail here in a couple of slides. And we will also have a couple of slides with before and after. So you'll be able to look at what some of the emails that came into the claims department looked like, and the risk managers took a stab at correcting them. And we'll see if you agree with the errors and then with the subsequent changes. This is broken up into 3 parts. We're going to look at the 7 deadly sins. We'll look at the 10 best email practices. And we may get to an email case study, but I was telling Ariana that I've done this program many times and I've never actually made it to section 3. So perhaps without the back and forth of a normal in-person presentation, we might actually look at item 3. But if we don't make it, it's part of your material, and it's a really interesting case study. So if you have an opportunity to review the material, and more importantly, to share it with your colleagues, it might be a great way to, have an interactive look at this program. This is provided courtesy of XL Catlin. I'm only going to spend a second on this. XL Catlin is one of the 2 largest insurers of architects and engineers in the United States. They've got almost 50 years of experience doing this. Their cumulative billings from their clients are over $17 billion. And over the last 10 years, they've returned about $200 million in premium credits to their policyholders. Policyholders in that program get really big credits for mostly 2 items. First is participating in things like this. It's good for every firm to stay fresh on risk management and best practices concerning, loss control. And the other way that they give out a credit is for the use of certain contract provisions, including limitations of liability. I think you can earn up to a 25% premium credit, which is a good offer from them. And there's lots and lots of risk management sources of help. And this is really just a placeholder to talk about this in general. This specifically relates to XL Catlin, but there's lots and lots of places for you to go to get help. Of course, you can tap into your colleagues. You might have an attorney on retainer or local counsel that can assist you. Your professional associations are fantastic resources for this. Certainly the ISPE is. Lean on your insurance broker. Your insurance broker and the insurance company that, when you're in private practice, that provides your professional liability insurance should have loads of information. And USI also has a library of risk management information. So if you're interested in getting, a contract guide or a contract checklist, feel free to shoot me over an email. My contact information is on the last slide of this presentation, and I'd be happy to send you over additional risk management information. We like to encourage people that are actually interested in risk management. So just let us know how we can help. Ariana mentioned that if you have questions or comments as we go along, we encourage you to participate. I think it makes it a lot more interesting for everybody that's on this call. And it'll also help guide me in case I have missed some obvious point that I can assist you with. Or, again, if you have your own war story that would add to the conversation, we encourage you. We can do it by you raising your hand or typing in a question, as Ariana mentioned to you. And depending on how in-depth it is, we can put you on the line also. So feel free to participate. We'd love to hear from you. So I'm going to give you a couple minutes to take a look at this. And what I'd like you to tell me or to think about is which of these email comments is from an actual claim case. I know you all already know that it's a trick question, right? It's not just one. All four of these actually come from real XL Catlin claims and disputes. So I'll run through these quickly, but we're going to talk about the topics in more detail in the coming slides. But the first one is an architect complaint about his client to another stakeholder on the project. Remember, it's a real dispute. Honestly, somebody thought that was appropriate. Sam, our client, is light years past difficult. The second one is an email from a design professional on a report that was critical of their design. So they end up acknowledging that they knew the design didn't comply with code during the design, which further implicated them while they were trying to explain away the materials failures on the project. This claim is closed. It had a $100,000 settlement and expenses on top of that. So 3, I have to admit, this fell into the, honestly, who would write this category? Because this email also included another comment, and give me just one second, I want to actually quote it here. The additional comment was, "We are embarrassed by our design errors." So, this is a project with unforeseen conditions, right? We've all seen that. It delayed the project, but the owner wouldn't extend the schedule. So as a result, the consultant was short-staffed, mistakes were made, but the problem was actually driven by the compressed schedule, and the client wouldn't acknowledge it, and the consultant didn't address it as that being the specific reason for the problem. This one is still ongoing. We don't know yet what the result will be. And the fourth is an internal email from a project manager to a project engineer on a project they were losing money on. So it was telling them to charge additional work to portions of the project they weren't actually working on. And, of course, and bill the client for that work. This was fraud. It was a real claim, $1 million settlement, and in excess of that for claims expenses. And I'm going to add a fifth one that doesn't show up here. The fifth one is a claim from my own claim files, and I refer to it as the FUBAR claim, and I'll give you the background on it. So it was an engineering client of ours. They were doing a tunneling project, and it was a successful project. It was good engineering. But during the course of the project, a project engineer had sent to a project manager an email that asked for, some particular evaluation of a particular sheet. And the project manager sent back an email and said, so I'm so glad you are asking me to take a look at this, because I looked it over and man, these designs are FUBAR, blah 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 blah. And the process goes on, and they identify the problem. They do the re-engineering as they need to. It was all internal. It was in the QA QC stage of the project, and at the end of the day, it's a good project. But it happened to be a public project, and the lowest qualified bidder was awarded the project. And at the end of the day, there was a claim for millions of dollars from the general contractor against the project itself for delays and extras. And in large part, what they talked about was that, really it was all the engineer's fault. I mean, it wasn't true, but the allegations were really it was all the engineer's fault. It was not good design. The contractor couldn't possibly have built it on time or on budget with that level of professionalism. None of it being true. But opposing counsel isn't really paid to agree with that. They are paid and charged with aggressively working on behalf of their client. And of course, one of the documents that they got was this FUBAR email. And so they put poor John Doe, the project manager, in the deposition. And the deposition sounds like, hey, John, we have this email that talks about your design being FUBAR. What does that mean? And John says something like, well, it means that we were in the initial stages and it, needed additional review and redesign, and we worked through it. Yeah, no, John, we really want to know, what does FUBAR mean? And of course he says, oh, well, it's just a military acronym meaning that it needed additional work. Yeah, for the record, John, give us FUBAR. And of course, the cleaned up version of FUBAR is either effed up beyond all repair or effed up beyond all recognition. So every question that got addressed to John after that was, so John, when you gave my client, the general contractor, those plans and specifications that you knew to be effed up beyond all repair, didn't it occur to you that they would never be able to bring this project in on time or on budget, et cetera, et cetera? It was a good engineering project, but because of that document, it was a mess for the engineer. There was really nothing wrong with that internal process so much as there was with the language that came back. That sort of language, that damning language against their own firm, absolutely unacceptable. It created a fiction that did not exist. It was a good firm. They were good engineers. The plans and specifications met their standard of care. But because of that email, it painted a picture that led people to believe otherwise. When you're in the courtroom, you are, you're up against opposing counsel who wants to prevail, but they will understand that they need to prevail by convincing a jury that, you were wrong. But these are complex and complicated topics that a jury of your peers may have difficulty following. They are a jury of your peers insofar as, they are breathing and they are U.S. citizens, but not because they are other engineers, right? I mean, the folks that are going to be judging you may have zero background in engineering. In fact, I think it's somewhat likely that they would have zero background in engineering. So opposing counsel figures out they need to create a theme. And if they create a theme, sometimes through some theatrics, they can just, work back into that theme and have the jury get behind them and understand these extremely complex topics. And I'll illustrate that. I mean, who here on this line remembers the O.J. Simpson trial, the first O.J. Simpson trial? Most of us remember it. And if you remember it, you probably remember the phrase that it turns on, which was something like, if the glove don't fit, you must acquit, right? Like if the glove don't fit, you must acquit. And then there was the theatrics in the courtroom with O.J. trying to get his hand into the glove, which of course didn't work, which we now understand from science was never going to work. And that was bad science and really shouldn't have been what the entire, case sort of turned on. But most people believe that it did. And you know the outcome, right? Like, he was found innocent. And that really was a case of a dream team. You know, they referred to his legal team as the dream team, the Kardashians, and they really did good job on behalf of their client. Thanks to the political environment in Illinois, we have some other examples of that too. And this is absolutely not a political statement, but some of our more recent governors have had some legal issues, one of whom was former Governor Rod Blagojevich. You might remember that he was actually sent to jail for having attempted to sell Barack Obama's Senate seat, I understand. So I didn't really follow that carefully, but I do have to say when it first came out, I remember thinking, that is questionable behavior for a governor. That does not seem like, the ethical thing to have done. But do you remember how they tried to change our opinion throughout the course of that trial? He really was not unethical. He was just not that smart. Do you remember that? He just was kind of dumb. And the reason they did that was you don't really go to jail for not being that smart. You go to jail for, breaching that obligation that you have to the public. In his case, it didn't work because we know that he is still in jail, or at least I believe he is. But, we don't want the theme to be, boy, that design firm could not communicate clearly to save their soul. So the more you do to stay on top of email and practice, good email etiquette and skills, the better off you are. Attorneys will tell you that the definition of email is it's those pesky documents that keep us busy during a deposition. And that really has escalated. I had a conversation with one of the attorneys that's working on, I don't know the formal name of it. I've been referring to it as the Leaning Tower in San Francisco. Most of you are probably familiar with the project. If not, look it up. It's very interesting. But there's a condo project in San Francisco that is leaning significantly, and there's all sorts of litigation and loads and loads and loads of people that are involved in this matter. And one of the attorneys that I was talking to said to me, part of the problem now isn't that we don't have documentation, it's that literally we have millions of records, and coming up with protocols to prove to the court that we're selecting the correct documents in and of itself has become, an art form and a really significant cost and time delay on these projects. So we're delighted to have email. I'm glad that it's there. I'm glad that it's memorializing things that were never memorialized before, but we're almost, swinging to the other side with creating so many documents that it's difficult to manage. But this program is about the 7 deadly sins. So first of all, let's get this out of the way. Here are the 7 deadly sins. I want to start listing them because I don't want us to spend the whole rest of the class trying to remember what they actually are. There are slight variations on these, given the many, many references that are available, but this is what we believe are the actual 7 deadly sins. But for our purposes, these are the email deadly sins. You're self-critical or confessional in your email. You blame other people in writing and make sure others know it. You complain about your client, the project, the subconsultants, your team, anything. You write like you speak informally, which is not always clear or precise. This is a record of communication, not a person-to-person conversation. When is the last time you used colloquial in an oral sentence? You write long emails with numerous questions or thoughts, or you don't read the full email before replying to only part of it. You love to talk about what you know, independent of the facts, or too much information. You provide information that's not needed and actually can be used against you in the future. But a better way to say this is, I messed up, you messed up, everything is hard and unfair, I sort of write like I talk, I'm lazy, I'm a know-it-all, or I write more than I need to. These are the 7 deadly sins. There's no need to confess in writing. Your emails can and will be used against you. In legal proceedings, emails have the same importance as that letter that we talked about earlier. Even though an email might have taken you, 2 seconds to read, to reply to, and to be done with, where, that more formal letter might have been hours of crafting and editing and then sending it out by snail mail. But in a courtroom, it means the same thing. A writing is a writing. And remember that for those of you that haven't had your records subpoenaed, generally the subpoena says, give us your records. Give us your records related to ABC. What it doesn't say is, hey, give us all those records that make you look good. It's just give us your records. So there will be many people potentially that look at this. Instead of being self-critical, oftentimes it's better to simply have an internal discussion and then follow it up with writing if you need to. And best risk management practices really suggest that developing a firm-wide quality management process is a great idea. It helps to avoid future issues, but don't tie the new quality management process to a specific project. When you get a subpoena for records, there are a couple things that you might be able to keep out of it. And this is why it's important if you do get a subpoena to ask for legal advice. One of the things that, generally you can keep out is client-attorney privileged documents. They have to be privileged. They have to be noted as such. There's some protocol for being able to keep them out of the subpoena, but, that privilege exists. There's also a self-analysis privilege, but I have been told by attorneys that I work with that here in Illinois, it is a fairly weak thought, but there is a self-analysis privilege. So if you can, or at least the possibility for this self-analysis privilege. So if you do use this quality management or a claim or a project to debrief and you use a quality management, you just want to have it set aside, right? Like, don't refer to it as the project name. Don't keep it with the project documents. You want to make it look like a learning tool that's independent of any project or client. Take a look at this and let me know what you think could have been edited from the email before it was sent. This is a real email, again, comes from an XL Catlin dispute, and these are not the correct names, but we'll call them Sirius Engineering as the consultant, and they made a mistake early on in their cost estimates for the project with their client, Skyview Communications. This quote is one of several email responses from Sirius Engineering to Skyview. The statements that Sirius Engineering made concerned, their increased fees, and it continued to escalate until Sirius Engineering actually walked off of the project. There was $4 million billed to date, and subsequently they were sued for breach of contract by the owner. This is another claim that is still pending, so we don't have an outcome. This is an illustration of how that same document could have been corrected. I love that first line. To be able to paint a true picture, come on, what does that imply? That implies that every other statement leading up to that point was false, right? To be able to paint a true picture, we need to lose that phrase from our speech. And then they go on to reconfirm how far off they were on their cost estimate. Probably unnecessary. The whole nature of this email, it appears, was because their estimate was off. So none of that was needed. You get to the same point by leaving all of that out. And your emotional state is not something that should be shared with your client. One, I don't know that they would really care about your emotional state, but secondly, if they weren't nervous, hearing that you are nervous certainly could ratchet that up for them. The statement simply is, I'm working hard to get enough information of what it'll take to complete the project. The status of each area is as follows, gets the point across. There are three types of blaming. There's blaming, transferring, and then CYA. Blaming is the act of making explicit and unfair accusations. Transferring is blame shifting, and then CYA is an action to protect yourself from subsequent criticism or maybe even legal penalties. So this is an internal email. The names are not correct, but the email is. And this is a real email between employees of a design firm. The consultant said they followed their quality management plan when they completed the project. They followed their best practices. So actually, the quality of their design wasn't the issue, or at least it wasn't the issue until this email was discovered. So the takeaway on this is, this probably would have been better as an internal discussion and not an internal email. Complaining and venting are similar. They express some level of dissatisfaction or pain, and venting is simply, ratcheting up the complaining a couple of notches. It's a higher degree or, next level of complaining. I'm happy to report that this disagreement didn't actually escalate to a claim. But let me start out by reminding us all that this is a real email. The consultant was actually cautioned by their own counsel about sending out these combative or complaining emails. But clearly they ignored that caution because this is a real email that we know about, because it did escalate to at least, a request for risk management assistance, but not to a demand for money or services. So stick to the fact of the issues. The issues in this particular case were all related to a late change to the exterior of a building that, a design professional didn't agree with, for a lot of reasons. And they didn't want to take responsibility for it at a later date. But this email didn't help resolve the issue. In fact, it continued to escalate it. So I don't know, this particular one sounds more like a failing romance than a professional relationship that's going sour. So no one wants to feel your pain. Remember to check yourself. Is this venting or is this an explanation? We may write in a conversational way, but email is a record of our communication, and we need to recognize and avoid writing that's not precise or not clear. These are three categories for unnecessary words: qualifiers, adjectives and adverbs, and filler words. I love the filler words definition on this. They sneak in between relevant words, add no meaning to a sentence, serve no purpose, and are generally useless. I have a teenager at home, So I'm very familiar with filler words and some of these qualifiers and adjectives that we don't need. In fact, she uses two colloquialisms. One is the word like. My teenager can manage to put like in a sentence 20 times. It's actually impressive when you hear it. And the other thing is she loves the word literally. She will say, I literally jumped 20 feet in the air when I heard such and such, to which I say, Ella, you do not know what literally means. I think you mean figuratively. We use that in speech. We shouldn't use it in our email. These are examples of poor qualifiers. My grandfather used to say, there's no such thing as kind of pregnant. Don't dilute the intent of your message by using poor intensifier words. It's either apparent or not. Either the calculations are wrong or not. There's no such thing as pretty much wrong. So don't say you're a bit confused, sort of tired, somewhat annoyed. Be confused, be tired, be annoyed. Qualifiers are adverbs of degree. These degree adverbs sound like completely, absolutely, extremely, excessively. Be thoughtful and be intentional, especially with your choice of words. On the witness stand, you don't get to redefine them, and you don't get to create your own version of the meaning. Remember where they're going to go, right? They're going to go to the four corners of the contract, or they're going to go to Black's Law Dictionary. So be thoughtful and be intentional. Whenever I'm reviewing a writing, it might be an email, it might be a contract, I scrub it a bunch of different ways, but one of the ways that I'm scrubbing is to hunt for adverbs and adjectives, because they're often unnecessary. We generally should use them sparingly. They're easy to be misinterpreted. They don't provide context. How big is huge? When you say poor, what exactly does that mean? What are the standards for that? So follow up with specifics. For example, my 3 concerns about the quality of the drawings are, 1, 2, 3. We think of these verbal fillers like and the omnipresent like, but there's filler words that we bring into our writing. For the reader, it becomes the equivalent of someone who repeatedly uses like in a conversation, which can undermine our sentences. Do you need to eliminate all the filler words? No. You just need to take out the unnecessary ones. So think about these phrases. Let's look at 4. 1. Due to the fact that we have limited resources. 9 words that could become 4 because of limited resources. Needless to say, we now need to close the office. Could be, we now need to close the office. And here's one that I'm a particular victim of. In order to reach consensus, could be simply to reach consensus. Or in the process of hiring new staff, could be, when hiring new staff. Do these things become claims? No. But does it set the picture that you may not communicate as effectively or as clearly as you could? Probably. This is an email from Vincent to his boss about a meeting he attended with clients. This may not be the claim, but it could certainly keep them in a claim that they may have been able to leave earlier. When you're presented with a claim, early on, what your counsel will do, if it is a possibility, is make a motion for summary judgment. A motion for summary judgment, which is also used, they use the MSJ acronym. It's a request for the court to rule that the other party doesn't have a case because there are simply no facts. You can argue that there's no material question of fact, that the opposing party can't win under the law. And if the judge agrees with you, you get taken out of the claim early on. Now, the judge isn't hearing the case. They're not deciding that based on the merits of your case. They're simply deciding it because there may be really no matter of law for keeping you in the claim, no basis for keeping you in the claim any longer. In a courtroom other than a bench trial, it's the jury that decides the outcome, but the judge does get this opportunity because it's a matter of law. The judge is presiding over the proceedings and they're maintaining order and they're talking about the specifics of the law itself, which gives them, the ability to weigh in on having you removed under a motion for summary judgment. Why is it a good idea? Well, first of all, go back to claims are not fun. Nobody wants to be a part of this process if you can avoid it, and it's expensive. The attorneys that specialize in this are likely to charge somewhere between $200 and $500 an hour. So keeping you in a claim to the bitter end to hopefully have you dismissed still can have some negative financial outcomes. I recently heard that the average length of litigation in Cook County had improved because it had come down to 5 years from 7 years. So you all can do the math much quicker than I can. You take a claim out for 5 years with, counsel that's charging it $200 to $500 an hour, and you can easily be racking up some significant dollars. Even again, ultimately, we hope that you're found not guilty, but still there would be significant costs with that. So, not giving the other side ammunition, not giving them at least something to argue to keep you in the claim is in everyone's best interest. We want to keep messages clear and concise, and especially from mobile devices. We're going to talk about that here in a couple of slides, but mobile writing lends itself to poorly written long sentences or cryptic sentences. And what does the sender really want from the recipients? Your quick reply may not address their items, requiring follow-up emails second time or third time. So be thoughtful and be intentional with your email. This message is 63 words long. 63 words that have no clear action item or request. The sender didn't take the time or make the effort to craft a message that was easy to follow or understand, which forced the recipient to figure out what the message is intending or what it's asking. The sender is probably unintentionally conveying that they have no interest in good communication. Ending any email with thoughts is not well written and looks, lazy. Thoughts on what? Is it appropriate to talk to the low bidder on our project? Is it appropriate to figure out what is acceptable to ask a low bidder on a project? I had a client last week that sent me an email about a new undertaking that their firm was considering. Specifically, they were talking about design build. They were, and the email set out all of this, thought process. Well, we're not sure if we're going to be the contractor or if we're going to hire the contractor. Some of the partners that want to get involved in this, we may create a whole separate entity. We don't know what that entity formation will be. We're not sure if it's a corporation. We're not sure if we'll sublet the design or if the design will be performed by that entity itself. One of our stakeholders in this new process actually has some good international connections, and there are some international projects we, might undertake. Thoughts. I could have written War and Peace on that. So I picked up the telephone. I had a general conversation. We scheduled a couple follow-up conference calls, and I confirmed it all with a brief email that thanked them for their time and just in general recapped some of the items that we had talked about. But break up sentences or shorten them. Keep messages from mobile devices specifically very short, and really be thinking about what does the sender really want from the recipients. And if you watch this for a second, you're going to see a redo on this blathering. The redo has fewer words, but more importantly, it's a lot easier to act on. There are specifics that you can respond to or that you're asking the recipient to respond to. I love this email because I tell you, I think it can happen to any one of us. So this is a real episode. An XL Catlin attorney was sitting in a mediation with a design professional who insisted that he'd never authorized the contractor's design change that caused the problem. And you know what happened? I mean, the mediator walked in with this email. And that lunch comment cost the architect $375,000. And here's how. So the claim is due to a question about the substitution. This whole thing defies the best practice of one topic, know your purpose, and having a clear ending, which we'll talk about in a few more slides. It does not have one question per email, and a key takeaway is, the one thing I need request. John Smith should have answered each question specifically, and he owns the poor email response as much as Harry owns the run-on sentence with 2 questions. So don't reply to an email without, 1, checking to see that you understood the question. Secondly, understanding either your own temper or the temper of the person sending the email. So I want you all to feel free to borrow my grandmother's rule. Everything looks better in the morning. So take a little rest before you send something out, especially if you feel like you're emotional concerning the topic or concerning the response. Or you can ask a colleague whose opinion or maybe temperament you trust before you actually hit the send key. And lastly, double check to make sure that your quick response is actually the right response. Self-indulgence, 3 categories. An opinion is a view or judgment not necessarily based on fact. Speculation is forming a theory without firm evidence. An exaggeration is representing something as better or worse than it really is. Now, you may be hired to render an opinion. Plenty of our clients offer up reports and opinions, but hopefully when you're doing that, you're using all of the important qualifying information about how you form the opinion, what the basis for the opinion is, and then appropriate disclaimers about what the limitations of the opinion are. So in this sample, a designer is responding to a report that was critical of their design. First, they acknowledged that they knew the design didn't comply with code during design, earlier in the email. Then, in trying to explain away the multiple failures of a single canopy pole, they provided their opinion that actually demonstrated that they were aware of this condition when they did the original design, but did not design for it. So this is an example of a self-incriminating and self-indulgent email. And of course, a real claim, this one did settle, and it settled for a little above $100,000. If there's a concern about a mistake, you should indicate the specific concern and then what next steps are. We all know folks that employ too much information. Consider these. Original too much information. Trevor may be brand new to the company, but he has a lot of experience. I'm sure we're fine. Given our last minute changes, I think this went better than expected. They could be rewritten to, Trevor has 12 years of experience with similar projects, which in my opinion is a benefit to the team. Or it would be really helpful if you could provide specific examples of the last minute issues you refer to in your email. So here's our takeaways. For self-critical self-analysis, don't document your self-critical concerns in a project-specific email or memos or lessons learned. There's no need to confess in writing. Your emails can and will be used against you. Might be better to have an internal discussion. Develop a firm-wide quality management process to avoid future issues, but don't tie that quality management process to a specific project. Have a meeting to discuss your concerns. For blaming, have a meeting to discuss your concerns. Document action items that are identified in the meeting, not your blaming. Complaining, stick to the facts, avoid the drama. And then 4, eliminate wordiness. Keep filler words that serve a purpose, such as ones at the beginning of a sentence, and when you can, edit out the rest. Be thoughtful and be intentional. Short, thoughtful messages are the goal. Before you send a reply, confirm you did the following. You understood what the email was asking, and you answered the questions appropriately. 6, stick to the facts. Review and edit your emails for forms of opinion and all forms of speculation and exaggeration. And then for 7, review and edit your emails, of course, for unnecessary facts. And now, let's look at some the optimizing steps. So these are 10 email best practices. Know your purpose. Why are you sending the email? Are you delegating work? Are you making a request? Are you setting up an appointment? And know your audience. Don't use abbreviations or euphemisms in formal emails unless they are clearly appropriate. You know, for example, if you say to me, LOL, the first thing I think of is limitation of liability. Might not be what you really meant. Could your message be taken out of context or misconstrued by different recipients? Know your audience. Write with your audience's perspective in mind. For best practices, it's a great idea to have a strong subject line. Be concise and specific. And remember that this subject line has a purpose. It lets the recipient, not know why you're even sending the email. And, you don't want someone to have to open your email to figure out what the message is about. So, an example might be question on your review comments or a landmark design action item due Wednesday. Be specific, have a strong subject line. A lot of our clients use these subject lines also to archive off communication to projects when a project has completed. So they'll use a particular project number or project code or project name that allows them to identify it as a communication related to the project, and then archive it off as the project closes out. What you don't want to do is introduce a new topic in the middle of an email thread. If you're changing the subject, create a new message with a different subject line. This happens to all of us. I think clients perhaps don't have my email handy, and so they do an email search on my name, they come up with an old email, and they just forward it to me with a new subject, but they don't change the subject line. If I'm lazy, which I hope I am not often, I reply to the email and I don't change the subject line because, mostly I'm thinking I'll remember that or I'll change that. And, if you don't, are you ever going to be able to find that email again? Or at the very least, is it going to be convenient? Probably not. I like this because right on the heels of telling you to be careful about using acronyms, we're going to use an acronym, BLUF, bottom line up front. It's the prevailing email best practice that, generally you should convey the why of why you're sending that email within the first 2 lines of the message. Don't make the recipient read to the end of the email to find out what the action item is. I know that we've all received emails that have many paragraphs in them. And what most of us do is scan, because that's the point of email. It's supposed to be short and concise. And when it's not, we either scan it or we put it into another stack to be read later. So, get to the point of your email quickly. As they say in journalism, don't bury the lead. Keep your email simple, one topic per email. Now the topic might be big, it might be a meeting note, so it might have multiple, sub items, but one topic per email. Be mindful of red flag words. First of all, review and edit for the 7 deadly sins that we talked about earlier. But be intentional and be thoughtful, because words really matter. They can be misinterpreted, they can be misconstrued, and that's what you're always working back into when you're proofreading your email. How can this be misinterpreted? How could this be misconstrued? It might be a little bit of CYA, but really what you're trying to do is to create the best writing for your recipient. But it happens to be on a parallel track with CYA. The more concise and clear your document is, the less likely that in the wrong hands it's going to be misinterpreted or misconstrued. But watch these words, absolutes, highest, all, complete, none, best, every. Remember, they're going to look in the dictionary. So if it isn't the highest or the most complete or going to happen every time, there may be a better word to use. And, it also includes, other absolutes like maintenance-free or watertight. Those absolutes will be judged against. And, promises are very difficult for design professionals because, structural engineers are in a group of folks known as learned professionals. You're in with a group of doctors and surgeons and architects and accountants and attorneys. You're hired for your skill and judgment, not for manufacturing a product. And you're going to be judged on a standard of care. The standard of care is a fantastic legal protection you have. You don't have to be perfect. You have to meet your standard. Your standard is the care and skill ordinarily used by members of your profession practicing under similar circumstances at the same time and in the same locality. It's not perfection. But warranties or guarantees or that language imply otherwise. It's black and white. You either met the guarantee or you didn't. You can't employ your standard, and there's 2 very dangerous impacts. One is you're going to lose the claim, right? If you guaranteed it would happen and it didn't, you lose, even if you met your standard. And secondly, when you lose, it's likely to be your payment and not your insurer's, because your insurance policy, your professional liability policy, covers you for what the law would hold you to. The law does not hold you to a guarantee or warranty, but you create that in writings. And a lot of words have multiple meanings too. Actually, I would put that word shall, that promise word in the second category, into multiple meanings too. Because, we all think of shall as sort of a sweet word. We shall do this. but it's actually an imperative command. It's a duty. We're required to do it. For example, the notice shall be sent within 30 days. In this case, that shall is a mandatory response. Historically, shall referred to obligation, while will referred to personal volition. So a few speakers still make that distinction, but in legal terms, it's usually upheld. He will do it. Thus means that he wants to do it, whereas he shall do it means that he's obligated to. Some experts suggest that email should be 5 sentences or less. Keep it simple. Write it first, then consider what you can cut from it. Is it clear? If readers have to scroll to read your message, are they really going to? Keep your message brief. It shows respect for your reader, and you have a better chance of it being read and responded to. If you have a difficult message to convey, say it simply and honestly, or maybe it would be a better choice to have a telephone call or a meeting. Avoid jargon. Use concrete, familiar words. Try to avoid technical jargon, qualifiers, redundancies, and generalizations, unless you're audience will understand it, and it would be called for in the writing, but be thoughtful and be intentional with that. Stick to the facts, don't complain or vent, and make your message easy to scan. Formatting like headings or bullets or numbered lists help readers get through the document. And have a call to action. Take a moment to proofread before you hit the send key. One of my clients gave me a sample of an email that they got from a contractor that ended with something like, I'm sorry for all the incontinence this caused. I'm pretty sure that's not what they meant. I'm pretty sure they used spell check, and whoever wrote the spell check dictionary had a wicked sense of humor that, when you misspell inconvenience, it comes up with incontinence. And put yourself in your reader's shoes. How would you feel about receiving the email you're about to send? Is email the right choice for it, or would it be better to have a meeting in person? And there is no such thing as a confidential email. Don't write anything private, confidential, incriminating in an email, and think about whether or not reply to all is appropriate. And I have to tell you, if there's a claim, emails marked confidential, don't say, oh, this is confidential, stay away. They scream, look at me. And, it's going to be the first email that gets reviewed. So, be careful with the way that you handle these. And personally, I don't use reply to all, or seldomly use reply to all unless I'm specifically instructed to, or unless I know everybody in the reply to all. If a client sends me an email, for all I know, my response could be controversial. So I'm unlikely to reply to all without being thoughtful and being intentional about it. And I also do not use blind carbon copy unless sometimes I read an interesting article and I send it on to some clients. I might use blind carbon copy then to protect their email address. But otherwise, if I'm sending an email to someone, if I'm not willing to tell them that I'm sending it to other people and show them that I'm sending it to other people, I don't think that I should be doing that. So I, again, no longer use blind carbon copy. Hey, Ariana, I think we're at 102. If I understood it correctly, for compliance purposes, we wanted to run this to 110. I've got just one or two more slides left. Are we still okay time-wise?
Yeah, go ahead and finish up. We haven't had any questions yet, but I guess this would be a good time for me to announce. If you have any, type them in now, and then we can wrap up with those after Melissa's done.
Fantastic. I should be done in just a couple more minutes. Thank you. And then the litmus test on this email is, would a phone call or some other direct conversation work as well, or maybe even better? And if you think it's going to be a surprise, definitely you want to call first and then maybe have a summary sent out in an email, and rewrite and review before sending, because the context is important. And before you send it, feel free to use Grandma's advice. Everything looks better in the morning. So you made it through those last three questions, and here are the final three. If you're still uncertain, don't send it. When in doubt, take it out, and a phone call might be more appropriate. Some of our clients do use text messaging. In fact, one of my clients told me that the project representative on the owner's side insisted that, during the course of the project that they use, text messaging, which, could be okay, but you have to be able to manage it. So, really what you'd have to do is, at the end of the day, you'd have to collect those text messages and fire off some kind of email, most likely confirming what your, various text messages were. Now, I do understand that there are software packages out there that you can purchase that helps you to capture the text messages coming off of particular phones, but that can be fraught with problems. And one of the issues could be is that you might be the only one of all the stakeholders on the project that actually has that software, which can, which would lead to, a lessening of the documentation that's available on the overall project in the event of a claim. So text messages are a difficult way to communicate unless you're sort of following it up with, again, email or more traditional letters. And with that, I'm just going to skip ahead here through the case study and let us land for a second on that last closing slide. So you guys have my contact information. Ariana, again, thank you for letting me be a part of your webinar series, and to the folks on the line, thank you so much for sticking with us for an hour on a topic that is a lot of insurance risk management and law. I know that that's difficult, and you deserve special kudos for making it through it. If you guys have any questions, if there's anything that I can do to help you, if you would like any of the risk management materials that I have in our library, like the contract guide or contract checklist, I'd be happy to share them with you. Just shoot me over an email. My email address is listed on this slide, and if you download the material, you'd have a copy of this in print. Ariana, what have I left off?
I don't think you've left anything off. I think you covered everything. We still don't have any questions, so maybe we can give it a minute if anyone does have any last questions or comments or anything. Go ahead and type it in now. I'll make a few announcements, and then if we have anything come in, I'll go ahead and read it. So I just want to remind everyone the link to the handouts and the quiz can be found in the confirmation email you should have gotten from us. If you're having a hard time finding that link, go ahead and email me and I'll send it to you. If you can just complete the quiz by this Friday, I can get you your PDH certificates via email the following week. Melissa, I just want to thank you for a great presentation. I want to thank everyone else who joined us today. This webinar is going to be posted on our website for purchase by next week. And last week's webinar is available for purchase now. So if you missed last week's webinar and you want to purchase it, visit our website, or if you have any interested fellow SEs, be sure to let them know. Also, don't forget you can check out our available webinars on our website and keep an eye on your inbox for announcements from me about new webinars as they're added. That's all I have. We haven't gotten any questions. So if anyone does have a question, feel free to email me or Melissa. And other than that, thanks again, everyone. I hope you have a good Wednesday.
Thanks, Ariana.